Today is a landmark day because we will be fulfilling our obligations under the Emergencies Act to commence this public inquiry. We want to begin by expressing our gratitude to Justice Rouleau, who is a sitting judge on the Ontario Court of Appeal, who has a plethora of experience in understanding the issues which will be brought before him in the context of this public inquiry. As Minister Blair said, we're looking forward to cooperating with Justice Rouleau to ensure that he has the access to the information, including classified documents, so that he can do his job. Also, just to underline that there are some procedural requirements to file the report to the conclusion of this public inquiry within 360 days of the expiry of the revocation of the Emergencies Act, which is February 20th, 2023. And we're looking forward to it. This is not just about checking a box off. This is healthy for our democracy, and we want to thank the Commissioner ahead of his important work, and I'll turn it over to Minister Blanc. Thank you very much.
Merci. Comme mes collègues ont bien exprimé, en février, lorsque les blocus et les occupations...
When the blockades and the occupations in various parts of the country threatened public safety, perturbed our economy, and affected workers and their families, our government invoked the Emergencies Act. The decision to invoke the Emergencies Act was made after deep reflection and with great prudence. We continually reevaluated this decision to make sure that the law would be in effect only for the duration needed. And when we revoked the law, we evoked the examinations that would follow, the reviews, including today's inquiry. We are announcing today this inquiry that we created. We called for an independent public inquiry, and Judge Rouleau will be the commissary. Canadians can be confident in Judge Rouleau's work with his team and the mandate given them to review the circumstances that led to the emergency situation and the measures taken to put an end to them. The Honourable Paul Rouleau is a jurist. As Minister Mendicino mentioned, he's distinguished with long experience, and he acquired this experience at the Ontario Court of Appeal and also the Ontario Supreme Court, and his long experience and skills will be very helpful as leader of this inquiry. The essential aspects and the Commission will operate independently from the government.
And would you do it again, like considering for this weekend the Rolling Thunder protest? Would you use this tool again?
Well, I think we can be unequivocally clear about a number of things looking back in the events of January and February of this year. One, the incredible and devastating damage that was done to public safety at ports of entry in the form of interruption to trade and travel, the interruption to supply chains, including with regards to vital health supplies, which Canadians needed on a daily basis, the disruption to public safety in our communities, in our neighborhoods, and the unique and unprecedented challenges that these illegal occupations and blockades posed. And it was only after very careful consideration on the advice of professional, nonpartisan branches of law enforcement that we invoked the Emergencies Act. It was a necessary decision. It was a responsible decision. It was the right thing to do. And we are certainly looking forward to cooperating with Justice Rouleau in the context of this public inquiry so that he has the fulsome record, as well as the Joint Parliamentary Committee, which is looking at this at the same time. Sorry?
Will you have full access to cabinet documents?
So on that issue, I will say, as Ministers Blair and Mr. LeBlanc said, that pursuant to the Act, the judge, the Order in Council, that the judge will have broad access, including to classified documents. Our intent is to collaborate with the judge so that he has a fulsome record, so that he can do his job. Pardon? Je vais prendre une question en français.
I'll take a question in French. Two questions. Will you give the council full access to all documents or some? I understand the distinction. It's a decision for the judge, and the judge is doing his job in an independent, impartial manner. It's a process that has a lot of integrity, and I don't want to preempt the judge's work.
Challenges that cabinet confidences have been cited as a reason for the federal government to not reveal its decision to invoke the Emergencies Act.
Well, I think it's important to distinguish that process from the process that we are launching today under the Act. There is litigation that is before a separate judge, a separate court, involving different litigants, and obviously will be up to that tribunal and that judge to make determinations about what access is required. What we are launching today is a public inquiry in fulfillment of our obligations under the Emergencies Act. And what I'm saying to you and to others is that our intent is to ensure that the judge has access to the information that he needs to fulfill his responsibilities under the parameters which have been set under the Order in Council. And we would point out that the parameters are there to guide the judge, but there is discretion there, including with regards to compelling witnesses, compelling documents, including classified information. So the question is, what information will be made public? That is a very important question which should be posed to Judge Rouleau. Today is the beginning of the process. It's not even the middle of the process, nor is it certainly the end of the process. And one of the hallmarks of this public inquiry is that he will have the capacity to function independently, impartially from the government. And it's one of the reasons why the government chose to make this a fully blown public inquiry, so that he could have the independence to make those decisions. Monsieur Leblanc.
Excusez. Quel sera le budget du juge Rouleau pour ses activités, pour ses employés, pour ses témoins, et est-ce que le gouvernement s'engage aussi à donner toutes les sommes demandées par le juge Rouleau?
What is the budget for the judge, for all his witnesses and so on? Are you committed to giving the amount he wants? We are committed to providing him with all the resources needed in this important inquiry. It's already written in law, a little over an hour a year, because we understand the urgency, we understand the need to provide all the resources he requires. And to answer another question, obviously, the report will be made public at the end of the process, and we think that the council will table it before both houses of Parliament to make sure full transparency. Inaudible. Obviously, there are standards with the Treasury Board. And this is the first inquiry in these circumstances. There are ways the Commission will interact with the Privy Council, and especially the Treasury Board. But the instruction to the Council of Ministers is to provide the Commission with all necessary resources, and the Commission hasn't begun the work. When he starts and comes before the government with requests, we'll make sure he gets everything he needs.
It's not legally binding, correct? These are recommendations. Is that correct? So if they're recommendations, what kind of impact will this have if it's not legally binding?
Well, I think our government has a very strong track record at taking very seriously the recommendations which are put forward by independent public officers. And it is precisely because this is a process that does imbue into the judge independence, impartiality, the power to get access to the information and the people that will provide him with a fulsome record to examine the circumstances that led up to the invocation of the Emergencies Act, as well as potentially making important policy recommendations and legislative recommendations should he so choose, to ensure this never happens again. And having had to live through what was an extraordinarily difficult time for Canadians across the country. I mean, I spent the last 2 weeks going to British Columbia, speaking not only with frontline law enforcement officers, to whom we owe a great debt of gratitude for their work in restoring public safety so that we could get trade and travel going again, so that we could get our economy going again, including here in Ottawa, where for those who live here, this town was under, it's hard to describe just how difficult that moment was for residents. But that's why the recommendations that will be put forward by Justice Rouleau will be taken very seriously by this government.
What was the thinking
involvement in preparing for the motorcycle convoy that's coming this weekend? Are you involved at all in the planning?
Well, we're aware that there are some reports that there may be another convoy making its way to Ottawa, and certainly I think coming out of the blockades in January and February, that there are lessons that are being incorporated into law enforcement, chief among which is the need for collaboration and open lines of communication among various levels of police services, which is why, again, today's launch of a public inquiry, which will be led by Justice Rouleau, is important. It is important that we take some lessons from the blockades and the occupation, and I know that that's work that he's going to undertake with great attention.
What was the thinking about tapping a current jurist as opposed to a former judge for this role?
Well, as Minister LeBlanc and Minister Blair said, Justice Rouleau has a depth of experience, both as a trial judge in the Ontario Superior Court, as well as a sitting judge of the Ontario Court of Appeal. He is well respected and brings with him, I think, the capacity to undertake this review with all of the impartiality, all of the independence, all of the integrity, so that Canadians can be confident that the Emergencies Act was a necessary tool and one that will ensure that we keep our Canadians safe and healthy going forward. Merci beaucoup.